Your dictation will start within 5 seconds. The respondents entered appearance and filed written statement denying the material allegations made in the plaint. Leaving aside the other facts in the present case, we may state here that a specific defense taken by the respondents in their written statement was to the effect that the suit was barred by limitation in view of Article 58 of the Act, because the suit having been filed after about 18 years of entering into the compromise by the parties in the High Court in the latter's patent appeal must be filed within 3 years from the date of entering into the alleged compromise by the parties. Accordingly, the respondents alleged that the suit must be dismissed on the ground of limitation. We make it clear that since the only question involved in this appeal is relating to the question of limitation, we have not considered the other aspects of the matter in this judgment. After the parties had entered appearance and led evidence in support of their respective cases also on the point of limitation, the trial court held inter alia that the suit was barred by limitation in view of Article 58 of the Act, as the cause of action arose on the date of compromise entered into by the parties. Feeling aggrieved, the appellants filed an appeal before the additional district judge Kanpur, who also dismissed the appeal of the appellants inter alia, holding that the suit was barred by limitation. Consequent thereupon, the appellants approached the High Court in second appeal, and the High Court also dismissed the appeal, holding that under Article 58 of the Act, a declaratory suit must be filed within 3 years of arising the cause of action for filing the suit. The High Court held in the impugned judgment that the cause of action arose when the parties had entered into the compromise, and therefore the suit having been filed on 21st of August 1990 was barred by time, since it was filed after 18 years from the date of the said compromise. As noted herein earlier, the only question, therefore, to be decided is whether the mere existence of an adverse entry in the revenue records had given rise to cause of action as contemplated under Article 58, or it had occurred when the rights was infringed or threatened to be infringed. Let us therefore consider whether the suit was barred by limitation in view of Article 58 of the Act in the background of the facts stated in the plaint itself. Article 58 of the Act clearly says that to obtain any other declaration, the limitation would be 3 years from the date when the right to sue first occurs. In support of the contention that the suit was filed within the period of limitation, the learned senior counsel appearing for the appellants before us submitted that there could be no right to sue until there is an accrual of the right asserted in the suit and its infringement, or at least a clear and unequivocal threat to infringe that right by the defendant against whom the suit is instituted.